Good morning. Delighted to be here. I'm going to, wait a minute, it's not me. Hang on. There we go. So I just press this? Yeah. I'm going to give you an overview of the Family Healthcare Decisions Act. It's a new law. It was long in coming. It was basically sitting around the New York State Legislature for 20 years, and until June 1st, we were only one of 2 states in the country that didn't have a law that empowered family members to make healthcare decisions for their loved ones. And it's particularly important for end-of-life medical decision-making. So the Family Healthcare Decisions Act applies to patients in hospitals and nursing homes in New York State. It empowers families and close friends to make treatment decisions for patients who don't have the capacity to decide for themselves, and it overcomes significant legal barriers by permitting those closest to the patient to make decisions based on the patient's known wishes and, if not known, in their best interests. And it doesn't apply to patients who have a health care proxy. The Family Healthcare Decision Act provides a list of surrogates in order of priority who have the authority to make decisions for patients who no longer have capacity. That list, which I'll go into in a moment and which you just saw, is very similar to DNR, but has a couple of changes. It repeals New York's DNR law, except for the law on non-hospital DNR orders. Obviously, DNR orders are still going to be written, but they're decided on new medical criteria that I'm going to go into also. It does away with the clear and convincing evidence standard for end-of-life medical decisions, except in the very narrow circumstance that Dr. Lesage described. That's a huge change, not having to find that clear and convincing evidence when making decisions to withhold or withdraw treatment at the end of life. It also, a very helpful feature of the law is it makes it possible to provide care and to withhold or withdraw life-sustaining treatment on patients without capacity who have no one to speak for them. And it permits artificial nutrition hydration to be withdrawn whether or not the patient has discussed his or her wishes with a surrogate. And again, as Dr. Lesage pointed out, this is different from the healthcare proxy law, where the proxy has to know your wishes and in a clear and convincing way in order for them to act on it. The good news is that you could make someone who's a proxy a surrogate for purposes of this decision. I mean, the laws are inconsistent, and I think the legislature will probably straighten it out. But in the meantime, if the person who's chosen as the agent is on the surrogates list, they could possibly become a surrogate for that purpose, and therefore not have to have had the discussion with the patient about their wishes in this area. It gives the surrogate authority to consent to HIV testing and HIV care unless the patient has requested otherwise. That's not explicit in the law, but there's a new HIV law that went into effect September 1, and in that law it is explicit that a surrogate can consent to an HIV test. It, of course, honors advanced directives made both orally and in writing. It doesn't alter the presumption of consent in an emergency, and it doesn't change existing law on assisted suicide or euthanasia in New York. New York still prohibits both practices. So I'm going to just walk you through this new statute and the procedure required to follow before decisions are made. First is determining incapacity. Decision-making incapacity under the law means the ability to understand and appreciate the nature and consequences of proposed health care, including the benefits and risks of and alternatives to proposed treatment, and to reach informed decisions. Every adult is presumed to have capacity, and a surrogate's authority is not triggered until the attending determines that an adult patient lacks capacity. The attending is required to make this determination to a reasonable degree of medical certainty, including an assessment of the cause and extent of the patient's incapacity and the likelihood the patient will regain decision-making capacity. For healthcare decisions which are not made at or about the time of the initial determination of incapacity, an attending must confirm the patient's incapacity. So this is fairly imprecise, but it's clearly meant to protect the patient whose capacity waxes and wanes, to make sure that before you act on a decision that you make sure they still have incapacity. In the event that withholding or withdrawing life-sustaining treatment is at issue, an independent concurring opinion as to capacity is required by a health or social services practitioner. Dr. Lesage mentioned that at our institution we've made a decision that health or social service practitioner be either a licensed PGY2 level physician or above, a nurse practitioner or a psychologist. If the attending determines that a patient lacks decision-making capacity due to mental illness, mental retardation, or developmental disability, then a second physician with certain qualifications must make that determination, unless, of course, the attending happens to have those qualifications. The Family Healthcare Decision Act does not apply to patients with mental illness who reside in OMH licensed facilities, and in some cases to patients with mental retardation or developmental disability who are in the hospital. So if they're coming from an OMH or OMRDD licensed facility to our hospital and then going back to that facility, then the rules that govern the mental hygiene law and the law for people with mental disabilities would apply. Let's see. Whoops. Okay. So the surrogate list here, very quickly, you just saw it. It's a guardian authorized to decide about health care pursuant to the mental hygiene law, a spouse if not legally separated from the patient, or a domestic partner, which I'll go into in a little more detail in a minute, son or daughter, a parent, a brother or sister, or a close friend. So a domestic partner is someone 18 years of age or older who meets one of the following criteria: is in a legally recognized relationship with the patient in any state or local jurisdiction, is a recognized beneficiary of a covered person under the patient's employment benefits or health insurance, or there's a mutual interdependence as evidenced by common ownership of a home, personal property, shared income, expenses, and children. Now, you're not required to make this inquiry every time somebody says they're a domestic partner, but if there are conflicts, which there will be, where family members disagree that person should be the decision maker, then these are the types of things that we look to confirm the relationship. And then a close friend is very similar to the definition under the DNR law. The difference is that you can present a signed statement. The close friend can. It doesn't have to be a sworn affidavit, which is what's required under the healthcare proxy law. So then there are these notice requirements under the statute. First, you have to the first thing always is to make sure there's no healthcare proxy, because that would trump this law. And if so, obviously they would have priority over anyone on the list. And then you would give notice to the patient of a determination of a lack of capacity and that the surrogate has been selected, if there's any indication of the patient's ability to understand. You then give notice to the surrogate who is highest on the surrogate's list, who's available, willing, and competent to serve. If the patient objects, this is a tough one, but it was true under the DNR law as well, that if the patient objects to the determination of a lack of capacity or to the choice of surrogate, the patient's opinion will prevail unless a court has ordered otherwise, or there's another legal basis exists to treat the patient, like an emergency. If the surrogate's unable or unwilling to serve, he or she may select another person on the surrogate's list to make the decision, as long as no one higher on the list objects. And then the next bullet, this should hopefully is already happening. The DOH has a publication that sets forth the patient and surrogate's rights and obligations under this new law, and that should be in the admission packet. And we should make sure when these decisions are being made that the surrogate has seen this. The Family Healthcare Decision Act grants the surrogates the authority to make all healthcare decisions that an adult patient can make, and the surrogate must decide about treatment in accordance with the patient's wishes, including religious and moral beliefs, to the extent they are reasonably known, and if they're not known, in accordance with the patient's best interests. And then for indicated treatment, all treatment decisions other than withholding or withdrawing life-sustaining treatment, hospital consent form should then be signed. So the next slide is about reliance on prior decisions, which in essence are very specific advance directives. And so the law states that if a patient has made a prior decision before they lost the capacity, including living will or advance directive, that it must be honored. And in order for it to be honored in the hospital, it has to have been stated in the presence of two witnesses 18 or older, one of whom must be a health or social services practitioner. And again, in our hospital, that's licensed PGY2 or above, a psychologist, or a nurse practitioner. If the patient has already made clear decisions, there's no need for a surrogate decision maker. But in that case, it's still required to make reasonable efforts to give notice to the surrogate of the patient's prior decision.